Balake. Where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Ron.
Ron is here, everyone, for some more SPTV. Wish I had some better news, but let me tell you what's going on. The judge in the Baxter Gawain versus David Miscavige Scientology et al. This is what's referred to in the press as the labor trafficking lawsuit against David Miscavige, has issued a ruling yesterday that the plaintiffs will be forced to submit themselves to Scientology's internal religious arbitration procedures, which, to anyone who understands a thing about Scientology, is completely incapable of acting as a fair and independent body. So this is not great news. It's not the end of the road for this lawsuit. The lawsuit is not being kicked out of the courts. It's not being dismissed. It's either being stayed or put on hold or whatever the correct legal language is. I'm going to share with you, by the way, in the description below, I have posted a link to this entire document. So please feel free to check that out and examine the whole thing for yourself. Let me read for you some specific sections out of this that I thought were interesting. Just getting my little views here sorted out. Okay, so check this out. Plaintiffs argue, the plaintiffs are the three former Sea Org members, the three former Scientologists who are suing. Plaintiffs argue that they are unable to vindicate their rights because the arbitration agreements do not allow for the selection of an impartial decision maker. While that argument is certainly consistent with a practical common sense view of the situation, it is not supported by sufficient evidence. Plaintiffs have failed to put forth any evidence showing that Scientology doctrine would compel an arbitrator to be hostile to their claims or would make it impossible for them to receive a fair and neutral arbitration. So real quick, I'm just going to provide some commentary on this here, if I can get my view sorted out. For the life of me, I cannot figure out how a judge could include that sentence in a ruling, because also the judge seems to feel that he's not allowed to interpret any portion of Scientology policy because that would violate rules about courts being allowed to interpret religious scripture. As a matter of Scientology policy, it is a suppressive act to assist a declared suppressive person in any way. It is not possible for a Scientologist in good standing, and a Scientology arbitration has to be composed of three Scientologists in good standing, comprising the members of the arbitration panel. It is not possible for three members of three Scientologists in good standing to find in favor of a plaintiff who's a former Scientologist and a declared suppressive person and is bringing complaints against Scientology. This is common sense. And I know that the plaintiffs did submit evidence of this. So, okay, let's go back to the actual document itself. Finally, plaintiffs argue they cannot vindicate their rights because they are not allowed counsel of their choice. By the way, guys, this is because Scientology says that the plaintiffs, when they show up for Scientology's arbitration, are not allowed to bring any counsel or representation or lawyers whatsoever. They're not allowed to bring anyone with them at all. Okay, the judge continues. While that argument also is consistent with a practical common sense view of the situation and an elementary understanding of simple fairness and justice, there does not appear to be any constitutional or statutory requirement that parties be permitted counsel at arbitration proceedings. The cases cited by plaintiffs in support of their argument are distinguishable on their facts. For the reasons stated, plaintiffs' prospective waiver of rights argument does not provide a bias to invalidate the arbitration agreements at issue here. Okay, let's carry on. First Amendment. Arbitration in a religious form has long been recognized as a valid approach to dispute resolution. Although plaintiffs argue their First Amendment rights would be violated if they are required to arbitrate their disputes, as former church members, there is no question they agree to abide by the rules and procedures of the chosen arbitration form. Plaintiffs' main authority in supporting their First Amendment argument is an unpublished California opinion, Bixler versus Superior Court for the state of California. Sorry, guys. The way I have this zoomed in, it makes it necessary for me to do this the way that I'm doing it. It should be noted that this opinion could not be cited in California because the opinion itself states that California Rules of Court, Rule 8.1115, restricts citation of unpublished opinions in California courts. In any event, Bixler is distinguishable because those claims involved alleged tortious conduct occurring after the petitioner's separation from the church and do not implicate resolution of ecclesiastical issues. The conduct alleged here occurred while plaintiffs were members of the church. Their claims do not implicate conduct after separation. Hold on, guys. For the reasons stated, plaintiff's First Amendment argument does not provide a basis to invalidate the arbitration agreements at issue here. And just a few more paragraphs in this thing, and then we'll be at the end. Okay, so duress and fraud. Plaintiffs argue that the agreements are void because they were signed under severe duress, which included imprisonment and threats of economic, reputation, and physical harm. If supported factually, this appears to be a strong argument, especially in light of California statutory and case law on this point, which seems to be considerably more liberal than other jurisdictions with respect to claims of duress, including claims of economic duress. The court directed supplemental briefing on the issue of duress, specifically whether the issue of duress should be resolved by the federal courts or must be submitted to arbitration and decided by the arbitrator. So real quick, switching views. Scientology's attorneys argued to the judge, and it sounds like the judge has ruled in their favor on this particular argument, that even if the complaint was that these arbitration agreements were signed under duress, Scientology's arbitration panel would have to be the ones to decide whether that was a valid complaint, not the courts. It's truly incredible, and truly incredible that the judge has agreed. Okay. The party's supplemental briefing has demonstrated that the law on this issue is not a model of clarity. Having carefully considered the arguments in case law, the court finds that controlling law on this point from the United States Supreme Court requires the issue of duress to be determined in the first instance by an arbitrator. Plaintiffs challenge the enrollment and departure agreements as a whole as entered into under duress. There are no factual allegations specific to the arbitration provisions themselves. The prima paint doctrine has been extended to require arbitration panels to determine many issues involving the validity of a contract with arbitration language, including allegations that such contract is voidable because it involves fraud, duress, or unconscionability. To summarize very briefly here, the argument that was made before the court really was, if the plaintiffs are saying that they were only under duress when they specifically signed the arbitration clause, then the court would be allowed to determine that matter. But if the plaintiffs are arguing that they were under duress when they signed the entire agreement and only one little piece of the agreement was the arbitration clause, then the arbitration panel has to be the one to decide whether that was actually signed under duress. Now, I would like to point out one little piece here where it says, and I hope I'm understanding this correctly, but it says, requires the issue of duress to be determined in the first instance by the arbitrator. With my layman's understanding of this language, I'm hoping that means that they're simply going to give the arbitration panel the first crack at making that decision. And then perhaps the court can wade in and determine whether they agree with how the arbitration panel conducted itself in determining, making that determination. I don't know if that's really what it means. That's how I read it. But I guess we'll find out. And I'll do a follow-up conversation with my attorney friend, Zach Morgan, about this to really understand what that language means. Okay, so let's see. Conclusion. Plaintiffs allege they suffered considerable mental, physical, and emotional abuse as a result of their participation in Scientology, which began during their childhood and included long stays aboard a large private cruise ship operating in the Caribbean. An uninterested observer reading the alleged complaint would likely be surprised and shocked by the conduct alleged. But under existing law, plaintiffs are limited to seeking relief through arbitration within the Scientology organization itself, not through the courts. This is what the law appears to require, even where, as here, plaintiffs allege they were forced to sign the agreements enforceable for 1 billion years under duress. An uninterested observer might also find such a limitation on access to the courts to be surprising and shocking, but a limitation appears to be required under governing law. On the other hand, it should not be forgotten that plaintiffs each signed numerous agreements to arbitrate disputes with Scientology over an extended period of years. The most recent agreements were signed in 2009, when Ms. Paris was roughly 31 years of age, and in 2015, when the Baxters were roughly 33 and 31 years of age, respectively. For the reasons discussed above, the arbitration agreements in this case are enforceable. Under existing law, this court's hands are tied. The court is not permitted to determine whether the agreements were executed under duress and therefore void. Instead, those issues must be decided through arbitration. However, defendants, and the defendants are Scientology and David Miscavige. However, defendants are not entitled to dismissal of the action. In accordance with 11th Circuit precedent, this case must be stayed rather than dismissed. Okay. I'm going to need my attorney friend, Zach, to explain for me why exactly that's such a big deal. I understand that the deal is essentially that at least the case is not ceasing to exist, but it's like, yeah, okay, so what? If the judge can't make any decisions in this case at all, who really gives a shit if the case is still in front of the courts? I need an attorney to explain that to me. Accordingly, it is ordered, adjudged, and decreed the motions to compel arbitration are granted to the extent the court finds that defendants may enforce arbitration agreements in this case. Okay, that's really all that matters right here. So, guys, it's bad news. It's bad news in the sense that many people were hopeful, including myself. Many people were hopeful that the fact that these agreements were initially entered into when the plaintiffs were children, the fact that so many issues of duress that seemed to a layman to be very common sense, black and white, cut and dry examples of duress were presented as evidence for why the arbitration agreements should be void. The fact that the judge seemed to be making some very logical arguments for why Scientology's arguments didn't really make a lot of sense. A lot of us were very hopeful that this was going to be a very important precedent in the unenforceability of the arbitration agreements. And so this seems to be a setback. I do need to have some more conversations with people more familiar with the law than myself. What do I know, guys? I grew up in a cult, but I do have some friends who didn't grow up in cults and are experts in the law. And stay tuned for some follow-up conversations on what exactly this means and what exactly it doesn't mean. Before I sign off, I did see a bunch of super chats pop up. So let me quickly go through and answer them, guys. John, Aaron, I sent you an email regarding second gen X groups last night. I know you get a million emails, so I just wanted to let you know here as well. John, I did see your email. I finished up pretty late last night, so I will answer you. Thank you, John. I appreciate it. Joe Taylor with a super sticker. Thank you, Joe. Much appreciated. Eat more pizza. I'd bet half of pizza coupons that many judges are in fear of Scientology digging up information on the judges. Well, it certainly is a possibility. I would argue that perhaps judges are perhaps more afraid of being overturned on appeal than they are of Scientology, but who knows? Maybe it's 50-50. Thank you, Eat More Pizza. Michael Kreger with a super sticker. Thank you, Michael. Michael Kreger with a super chat. Graham filed a similar argument for me in my court case, and the judge did not allow Scientology to be discussed at hand. We set precedent. Okay, I think your case was a family court case. I'm not sure what the carryover is between courts or what I forget what your jurisdiction was, Michael, but that's interesting. Thank you for that comment. Joe Taylor with a super sticker. Thank you, Joe. KPSI Bobby with a super sticker. There we go. Okay, let's see. Broken dishes. OMG, it's like getting a divorce and you're just no mother-in-law. You're just no mother-in-law being allowed to decide child custody, asset distribution, etc. I know. It's absolutely incredible. Lydia von Stretchclaw. Lydia, always good to see you. If Scientology are made to explain their arbitration process and the judge specifically asks them about the prohibitive elements of it, could that circumnavigate the whole restrictions on interpretation? Well, perhaps, but Scientology's attorneys are smarter than that. They tell the court which Scientology policy governs the procedure of the arbitration process, and then they say, we're not allowed to tell you that policy, and we're not going to tell you the procedure of that policy because you're not allowed to know it or make any determinations about it. So, yeah, Scientology hires the best attorneys for a reason. Okay, KPSI, Bobby. I want to become a lawyer just to help take down this organization. Scientology is taking advantage of our legal system. Let's bring them down. Indeed. All right, everybody, that is all I have on this for now. Much more to come today. Stay tuned for some more SPTV. Hit that like button, please. Hit that subscribe button. Thanks for everybody who sticks around and watches until the very end, and I'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe right here. Bye.